by comments from Attorney General Merrick Garland.
I appointed Jack Smith as special counsel to take on the ongoing investigation in order to underline the department's commitment to accountability and independence. Mr. Smith and his team of experienced principled career agents and prosecutors have followed the facts and the law wherever they lead.
The former president reacting on social media, claiming the case is being brought now to interfere with his presidential campaign. And this morning on the Today Show, Savannah Guthrie sitting down with a very combative Trump defense lawyer, John Lauro. The prosecutor says, well, let's go to trial. I'm ready in 70 days. Fair enough, you're not ready in 70 days. How about 90? How about 6 months? How about before the election?
How about he had 3.5 years? Why don't we make it equal? Okay. The bottom line is that they have 60 federal agents working on this, 60 lawyers, all kinds of government personnel, and we get this indictment and they want to go to trial in 90 days. Does that sound like justice to you?
Well, maybe.
Is that justice?
The prosecutor's not here to say. Maybe he's investigating so that he's ready to go to trial in 70 days.
Is it justice to force a former president of the United States to trial in 90 days when you've had 3 years to
Well, as you well know, no one can force that. As you pointed out, it is the
defendant's
right to a speedy trial.
Why would a prosecutor ask for that? Why would a prosecutor seeking justice, seeking truth, try to force a trial?
Well, I don't know, but you just told me 10 seconds ago that they wanted to tie him up in court so he can't run for election, and now you're telling me they're trying to force the speedy trial.
Right now.
So which one?
The election's going on right now.
Okay.
They want to go to trial so that instead of debating the issues against Joe Biden, that the President Trump is sitting in a courtroom. How is that justice?
And joining me now, NBC Justice and Intelligence correspondent Ken Delanian, former U.S. Attorney Barbara McQuaid, and Andrew Weissman, former FBI General Counsel and the former lead prosecutor for Robert Mueller's investigation into Russia's interference in the 2016 election. So, Ken, I want to start with another excerpt from the indictment on Trump's alleged fraud claims. He writes, "These claims were false, and the defendant knew that they were false. In fact, the defendant was notified repeatedly that his claims were untrue, often by the people on whom he relied for candid advice on important matters and who were best positioned to know the facts. And he deliberately disregarded the truth." So, Ken, this indictment gives us a very strong sense of how the special counsel is going to approach this prosecution and pushing back strongly against the free speech defense that you just heard from John Lauro.
It really does, Andrea. In fact, it says right up front that Donald Trump had the right to say that there was fraud in the election, and he even had the right to lie about it. But the passage you just read goes to the crux of the case, because they have to prove that Donald Trump knew that the things he was saying and acting on, crucially, were lies. And to do that, they have to show criminal intent. And, of course, he's going to argue, and you heard his lawyers, you've already heard them arguing that he legitimately believed that there was fraud. The issue with that defense is it seems to a lot of people that it would require Donald Trump to take the stand in order to articulate that defense to a jury, because who knows Donald Trump's state of mind, and what's the best evidence of that better than Donald Trump himself? Well, we all know that that would be legally perilous for Mr. Trump to testify in his own defense. So in a sense, the special counsel may have set a bit of a trap for Trump there. Stepping back, this is an incredibly detailed, descriptive 45-page speaking indictment. Some called it a screaming indictment. But at the same time, in the scope of this case, it's fairly narrowly crafted. It appears designed to get to trial quickly, in part because it's charging only one defendant and leaving uncharged the 6 co-conspirators, and in part because we're not seeing allegations of, for example, incitement of the January 6th riot or insurrection or seditious conspiracy. They chose not to bring those charges, and instead they're looking at the conspiracy to defraud the United States and to obstruct an official proceeding.
And Andrew Weissman, the defense strategy seems clear from the Today Show interview, including, of course, talking about the free speech issue, but to put the trial off as long as possible, basically till after the election.
Absolutely. So a couple things. One, it's important to remember that the rule of law includes due process for any defendant. And Mr. Lauro, although I wouldn't have articulated it perhaps in the exact same way, is right to say that he does need, the defendant and his team needs enough time to prepare for trial, to make motions. That is part of what it means to be committed to the rule of law. The judge will set a trial date consistent with that. Remember, the judge has a history of being a defense lawyer. But as Judge Ludig has said recently, respected former federal judge, saying that there's nothing about the due process clause that would prevent this trial and the Mar-a-Lago trial from being scheduled before the general election. And finally, it is worth noting that it's not like this indictment took the defense team by surprise. They have had months and months and months, if not years, to prepare for this. They have seen the January 6th committee. This is not somebody who just landed in America and suddenly realized they're now under indictment for something that happened 3 years ago. So they're in a very different situation than that kind of defendant. But they are entitled to time to prepare, and I am confident Judge Chutkan will give them that sufficient time. But I do think that this case can be tried and should be tried before the general election so that the public has the benefit of that information, regardless of what the verdict is, prior to casting their votes.
And Barbara, I just want to play another exchange between Trump attorney John Lauro and Savannah Guthrie. Get your reaction on the other side.
Yeah, I assume you're confident you can win this case.
Absolutely, we're going to win.
Yeah, would you, at a minimum, say you'd like to see this resolved before the election?
I want to get to all the evidence. I want to have a chance to present our case to a jury. This is the first time that the First Amendment has been criminalized. It's the first time that a sitting president is attacking a political opponent on First Amendment grounds and basically making it criminal to state your position.
So, as Savannah pointed out, Barbara, the indictment reads, the defendant had a right, like every American, to speak publicly about the election and even to claim falsely that there had been outcome determinative fraud during the election and that he had won. But prosecutors say the defendant also pursued unlawful means of discounting legitimate votes and subverting the election results. So that's the point. It's not his speech, it's what he did, following up on his speech.
Yeah, the First Amendment is not going to provide any valid defense for Donald Trump here. It may sound good to the public, it might sound good to some of Trump's supporters, but it wasn't simply that he said I won the election, it's that he took action to try to change the outcome of the election. And the indictment is replete with references to all of those allegations, pressuring Mike Pence, gathering false slates of electors, trying to weaponize the Justice Department by sending letters to legislatures suggesting they reconvene and substitute their own slates of electors, pressuring Brad Raffensperger in Georgia, asking him to find 11,780 votes. It's all of that conduct that is the gist of this case. The Justice Department, as Ken pointed out, I think showed some restraint here. Jack Smith showed some restraint here by not charging things like inciting insurrection, which could have brought, perhaps, a First Amendment defense. I think he deliberately left that out so the case could be streamlined to avoid any valid First Amendment defense here.
And Andrew, this key player hanging over a lot of this is Mark Meadows, the former chief of staff. So Chris Christie told me last week that he thought his response when people tried to question him coming out of a building the other day, we know he did testify, and he wouldn't comment on anything that he'd said at all. Do you think he might be a key player here as a witness for the prosecution?
It's unclear. The best tea leaf we have with respect to Mark Meadows is that he is pretty clearly not one of the 6 co-conspirators and those 6 co-conspirators are their conduct is set out in a remarkable way in this indictment. I've never seen that much detail about people who are not charged in an indictment. Of course, they're not named in this indictment, but Mark Meadows does not seem to be one of them. So it's unclear whether he is cooperating or fully cooperating, or whether he is going to be in this sort of netherworld. I would say, Andrea, that my reading of the indictment leads me to think, and I can't assure you of this, that those 6 people will be facing charges, and unless there's been an indictment under seal already. But I don't think they would be charged in this current case because, as we've talked about, I think that this will be one defendant, so it can go to trial quickly.
And Barbara, I also want to focus on the violence. It's such a central part of this, the allegations, and read this excerpt from the indictment. The Deputy White House counsel reiterated to co-conspirator 4 that there had not been outcome-determinative fraud in the election, and that if the defendant remained in office nonetheless, there would be, quote, riots in every major city in the United States. Co-conspirator 4 responded, well, to the Deputy White House counsel, that's why there's an Insurrection Act. In other words, the Insurrection Act authorizes the president to send the military domestically in the streets against American citizens. So we also saw the reference to John Eastman's comment that violence is sometimes necessary to protect the republic. They were counting on violence to enable this alleged conspiracy.
Yeah, I think that just shows how sinister all of this is. You know, the idea that insurrection or violence in the street or civil unrest are something that we should deliberately unleash is incredibly irresponsible, especially for people, one of whom may be Jeffrey Clark, who was at the Justice Department at the time, responsible for enforcing the rule of law. And so it's interesting that although this indictment does not charge insurrection or seditious conspiracy, it certainly notes that this group of co-conspirators understood the seriousness of these actions and that it was very likely that it would lead to violence.
In fact, 5 of the 6 who we believe are the co-conspirators are attorneys, and maybe all 6. We don't know about the 6th. Ken Delaney and Andrew Weissman and Barbara McQuaid, thank you very much. And up next, those unnamed co